City of Riviera Beach Planning and Zoning Board meeting. Today's Thursday, September the 28th, 2023, and it is now 6:32 p.m. Let's move on to a moment of silence. Please stand for the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God,
indivisible, with liberty and justice for all.
Roll call.
Anthony Brown,
Present.
James Gallant,
Here.
Renee Burgess, Margaret Shepherd,
Here,
William Wiley,
Present.
Frank Fernandez.
Present.
You have a quorum.
Thank you. Acknowledgement of board member absence notifications.
None, Mr. Chair.
Additions or deletions to the agenda.
None, Mr. Chair.
Disclosure by board members, none because it's a legal in-house tutorial. Adoption of the agenda. Do I have a motion?
so move.
Second.
Anthony Brown,
Yes.
James Gallant,
Yes.
William Wiley,
Yes.
Frank Fernandez.
Yes.
Unanimous vote.
For the record, we have no approval of minutes.
Excuse me, how did I get left out of that one?
Margaret Shepherd.
I didn't say nothing.
My apologies, Ms. Shepherd.
I thought she did.
I thought she said.
May I have your vote, Ms. Shepherd?
Yes,
We're
Thank you,
so
ma'am.
sorry.
I'm overlooked, I understand.
My sincere apologies, and now we have a unanimous vote.
Thank you very much.
You're welcome.
Ms.
Remember, you are the community conscience of this board.
Oh, okay. Be careful what you ask for.
Since we have no approval of minutes before us, there's going to be none. Am I correct, Ms. Davidson?
Yes, sir, none at the moment.
And unfinished business,
None, Mr. Chair.
new business,
None.
general discussion, no public comments, staff updates, correspondence.
So just to provide notice that the next scheduled Planning and Zoning Board meeting is scheduled for October the 12th.
October 12th.
Yes, sir.
Okay, now we move on to workshop item, training workshop session, Planning and Zoning Advisory Board.
Mr. Chair, if I may,
Yes, sir.
as you are aware, training is a regular part of our operations here as the Planning and Zoning Board. And today we have earmarked this agenda to hold the next training for staff as well as the Planning and Zoning Board. For this training today, we have the privilege of having Ms. Tanya Early of Torsivia, Daniel and Gatto law firm to assist and lead the training today. And she, as well as staff, are available for a informative, but also a dialogue for this training. So we are happy to have her with us today. Ms. Early.
Mr. Simons, thank you for the introduction. Chairman, board members, again, my name is Tanya Early, and I'm here to talk to you about various topics that are relevant to your service on the city's Planning and Zoning Board. I actually have two presentations today. You have one of them which is printed out. We'll make sure that all of the board members get copies of both presentations electronically, and I will go as quickly as possible and as efficiently as possible. So with that said, let's jump in. The first presentation is regarding sunshine, public records, and ethics laws. I have just a few goals for this presentation, and that is that we're going to cover the basics of the sunshine law. We're going to talk a little bit about public records. We're going to talk a little bit about ethics, and we'll leave some time at the end for questions and or comments. Just a couple disclaimers at the beginning. there's impropriety and then there's the appearance of impropriety. So what we want to do at all times when dealing with these issues is to avoid even the appearance of impropriety. I also want you to keep in mind that each issue is unique. So this presentation is designed to give you basic and general information, but if you have specific questions or a specific concern, you're definitely advised to contact city staff and/or the city attorney's office. And if there are questions about ethical issues, you can also contact the Florida Commission on Ethics, and that would pertain mostly to voting conflicts in this context. So first topic, the Sunshine Law. So everybody knows, generally speaking, that the Sunshine Law prevents meetings of local government body boards or advisory boards, which the Planning and Zoning Board is an advisory board. They prevent meetings from happening in secret. So what the law says basically, and how it has been interpreted, is that when two or more members of a public board speak with one another or communicate with one another and discuss something that could foreseeably come before the board, that constitutes a meeting under the Sunshine Law. So something to keep in mind is that this meeting can happen in person. You can see a board member at Publix and start with small talk and quickly veer into topics that might come before the planning board. And it's very easy to accidentally fall into this. So I would advise, if you see any fellow board members out and about, keep it to safe topics that have nothing to do with your service here at the city, nothing to do with anything that in any way, shape, or form might foreseeably come before the Planning and Zoning Board. This also applies to any emails that you might send one another. They should be kept strictly personal or strictly regarding other matters that do not pertain to your service on the Planning and Zoning Board. Even if you have an issue where you know you're going to be conflicted off, you know that a project is going to come before you where you know you have a conflict and you're not going to be voting on it, you still should not be speaking or emailing or contacting your fellow board members regarding the issue. The same goes for text message and social media. So with social media, we have to be careful because even something as simple as commenting on somebody's Facebook page or liking a comment or something like that, given a thumbs up even, could be perceived as a meeting and a back and forth discussion that has occurred online. So you want to just be careful, just try to, again, separate your service here on the Planning and Zoning Board from personal and other matters, especially when communicating with one another outside of this room. Any questions about that?
For clarification purposes, and Ms. Shepherd brought this up at one of the other meetings, most of the developers often have open houses for the community to listen to the community. We've also had comprehensive plan meetings here held by the city, which we have attended. Technically, by the way, just describe this, we can't attend any of the comp plan meetings or anything that will come before us. I mean, give us an explanation. Can we not?
Well, technically speaking, the meeting occurs when there's conversation, when there's back and forth discussion. So technically, could you all be in the same room and you're in the different four corners of the room not speaking to one another? Would you be violating sunshine? No, technically. Could you put yourself in a situation where a fellow board, where you might, let me rephrase that. Could you put yourself in a situation that might slide into an inadvertent violation of sunshine? Yes. So I will tell you that there are some city council or city commission, elected official level boards where they just will not go to community events if they know another commissioner or another council member is going to be there, because they don't want the appearance of impropriety and they don't want to open the door for someone to say that there's been a violation of the Sunshine Law. You also have to be careful in that you cannot use a third party to pass messages between board members. So again, this could inadvertently happen in such a meeting that, you know, you have one developer or one representative that's going from board member to board member. It's just, it's a slippery slope. So I'll leave it at that. I don't think you like my answer, but
Move on.
any other questions, Mr. Chair?
Are we gonna wait till the end, or are we gonna, or can we ask questions as you, for different sections that you're on?
I would rather wait till the end, but
Okay.
I know that particular section usually generates a lot of questions.
Right.
So since we were there, I thought I would pause for a moment.
Okay, so you rather me wait?
If you have a question about that slide, I say let's go
Okay,
ahead.
yeah, so my question is, the Sunshine Law, just for clarification for ourselves and for people at home, the Sunshine Laws, are they strictly between P and Z members? Are they between P and Z members, board members, council members, or whatever like that? Does it all fall up under the same rule?
That's a great question. So the Sunshine Law applies to members of the same board. So each of you is allowed to speak with members of a different board on an individual basis, and you're not going to violate Sunshine. If you share the same board, however, you cannot speak with one another outside of a public meeting that checks all the boxes under Sunshine. Does that make sense?
Oh, yeah, absolutely, but let me see if this makes sense. If both boards are going to be voting on the same topic at some point in time, at that point, will those conversations violate Sunshine Laws then?
No, you only violate Sunshine. There may be other issues that come up with what you're saying, but you're only going to violate Sunshine if you speak with a member that is on your same
On
board.
the same exact board?
Yes, sir. So all of the people that are on the dais with you right now. Now, one area where you're going to want to be careful is if you are on multiple boards and you have other board members who are on multiple boards, you're going to want to be aware of that, and you have to balance. You have to be careful that you're not going to mix topics and mix boards and mix discussions outside of a publicly announced meeting.
Thank you.
Yes, sir. Any other questions about this slide before I move on? Okay. All right, so what are the basic tenets of the Sunshine Law? They are reasonable public notice of a meeting. Staff usually takes care of that. That the meetings be open to the public, so no closed door meetings. And after the meetings, minutes have to be promptly recorded, which is why they show up on your agenda every time. And again, staff takes care of that. And the last component is the ability for public participation. That was added more recently. And it is a requirement under the Sunshine Law, but there are some, it's easier to recover from a failure to allow public participation in some circumstances than it is to recover from a failure to meet one of the three items that are before that. That said, there should always be a public comment period. Especially if it's on your agenda, you should be careful not to skip that. Okay, so what happens if there's a violation of the Sunshine Law? Well, whatever the board decides upon will be void. It'll be as if it never happened. So a rezoning that gets done it's like it never happened. An ordinance that gets passed, it's like it never happened. So that's something that would be just automatic upon a court's finding that there was a violation of the Sunshine Law. Now, that's going to have a negative impact for the city. There are negative impacts that affect individual board members if you violate the Sunshine Law. So if you inadvertently violate the sunshine law, you could be subject to civil penalties and fines up to $500. If you do it on purpose, that is a second-degree misdemeanor, and it's punishable by up to 60 days in jail and or a combination of probation. So definitely you don't want to do that on purpose. You don't want to, and you want to avoid putting yourself in any situation where you might inadvertently do it. Other negative effects that really apply at the city level is the city could be sued in court to have its legislation held to be invalid. And if the city loses the lawsuit, the city then has to pay the attorney's fees for the plaintiff. So there are a number of negative impacts associated with violating sunshine, and that's why it's very easy to violate sunshine, and there are lots of negative impacts that come with it. So that's why, when I say be careful, avoid the appearance of impropriety even, I'm not being paranoid. It's just that's the way that the law is structured. So what happens if there is a violation? The courts have said that there is a way to cure it. And the way that a violation is cured from the city's perspective is to redo the public meeting, have proper notice, have an opportunity for public comment, and it needs to be not a rubber stamp of the original decision that was flawed in its process, but a complete redo with genuine discussion about the outcome. So like I said, there are things that there are cures that are available to the city if there is a sunshine violation, but the personal impacts to you, the civil fines, potential criminal action, those are things that will not go away once they're imposed. Okay. So the next topic is Florida's Public Records Act.
I'm sorry. I have a question. I
Yes.
apologize. So during right now, we're in the process of our comprehensive plan update, and they're publicized meetings. They're already publicized that we'll be having these meetings, and the topics that are discussed there are things that are important to our board as well. To one, hear what people are saying, but to two, also learn what all is being proposed. And I'm wondering, for sunshine purposes, because we already have it advertised, we say that we might have more than one, can discussion, not necessarily amongst themselves, but let's say by chance discussion happens and they're like, oh, we're thinking about this. Is that also?
If it needs to be an advertised meeting of the Planning and Zoning Board in particular.
In particular?
Yes. So again, I would be careful with that, but I'd be happy to talk with you tomorrow, as soon as tomorrow, to try to work through some alternatives or some ways to approach the issue.
Excellent.
Okay.
Thank you.
No problem. Okay, so public records. There are multiple provisions in Chapter 119 Florida statutes. I'm not going to read the entire slide to you, but basically it defines what a public record is. It says who has to keep them. It says who has access to them. It provides exceptions. The law also provides for lawsuits to be filed against the city if a request for public records is not complied with, and if the plaintiff wins that lawsuit, again, the city has to pay the plaintiff's attorney's fees. Now, what is a public record? Basically, what the Attorney General has said is that it's all documents, papers, letters, maps, books, tapes, photos, any material in any form. It could be in electronic form, it could be in paper form, it could be a video, as long as it's made in connection with the transaction of official business, and it is a public record. It also needs to be intended to perpetuate, communicate, or formalize knowledge. That's a lot of words. And I'm going to skip actually to the next slide because I think the next slide is going to provide more helpful examples. So One example would be emails from city staff about your board meetings and the timing of those meetings, et cetera. Any emails from city staff to you regarding your board service, as a matter of fact. The agenda and all the backup documents, any communications that you may receive, even on your personal email, from applicants, fellow board members, et cetera. Again, social media posts, texts, emails, anything that you have that discusses your service as a board member is essentially a public record and should be considered as such. Now, this last point on the slide, if city staff is in possession of your email address or other information, unless it's protected under some other law, that is public record as well, unfortunately. So what's not a public record? That's going to be, I'm assuming nobody here has a city email, right? No. If you had a city email and you had personal emails on that from friends, family, whatever, those are not public records. Personal text messages on a city-issued phone are not necessarily public records either. There may be internal policies with the city about maintaining those types of things. Just a social media post about more general issues not related to your board service, that's not a public record either. But that's a fine line. It's very easy to cross that line. I would just be very careful. So I just wanted, not a war story, but I have seen a situation where emails amongst fellow board members have been requested as a public record, and I've had to turn those over before. So just anything you write in relation to city business, just assume that somebody else is going to see it one day, and assume even more so that it could possibly end up on the front page of the newspaper.
Sir,
Yes, sir.
how do you consider a phone call from somebody who has an agenda, something on the agenda coming up? How do you consider that?
Well, that's a good
How do you
question.
address it?
Who's making the phone call?
The person is making a phone call to you and wants to talk to you about, his issue.
Like an applicant or
Yes.
a member of the
Yeah.
public?
Yes.
So the phone call itself is not a public record. However, if they leave you a voicemail, that voicemail could be public record, would be public record, in fact, if the voicemail talks about your city business or things related to your service as a board member. So that's an example of a situation where the recorded message is a public record, but your conversation is not.
Chair.
Yes, Mr. Chair?
Yeah, Chair, I was
Yes, sir.
asking to be able to ask a
Yes, sir.
question. Okay, I was looking at some information also, because I'm gonna have a couple questions at the end.
Yes,
I
sir.
was looking at what is a public record, and it says advisory board members' home address, home, personal cell phone, and others' personal information provided to the city. So any information that we have that we provide to the city, that can be requested as a public record, and anybody can receive it.
Yes, sir.
So if anybody else receives that information and take it and put it on the internet or whatever like that, then who's at fault of that?
So if you provided it to the city in terms of an application for anything,
For a job,
for a
right.
job or anything like
Right.
that, that information is public record and it can be turned over. There are certain exceptions to that. For example, if you are former law enforcement, then the city can, they would turn over the record, but they would redact
Right.
your personal information. So there are limited exceptions to that, but for the most part, that's just the way that the law has been interpreted.
But it just had to be further clarification to that, because we have situations here in the city that this information this has happened, and the city has put themselves in a situation to where they possibly could be sued. And then there's no verification of what or where it came from. So then how at that point, if any information that we provide from the planning and zoning board to the city, to where that information, especially someone's home, phone, or any information that they provide to the city, none of that should be able to, for myself, none of that should be available to a parent. Like, for example, I'm a school teacher. A parent shouldn't be able to walk in and be able to get my address and my phone number and be able to call me unless I give it to them, right? So at that point there, now, if you have any situations that may happen now, then who's going to be at fault or responsible for anything that may happen?
Well, the law says that if something qualifies as a public record and it is requested, it's like that last part that's underlined there. If it is a public record, it must be released to the requester unless exempted by law. So the law is structured such that the city is required to comply with the request unless there is an exemption, for example, law enforcement. I can't remember off the top of my head if there's an exemption for teachers, but we can talk offline after. But it's limited. It's limited. So, so to answer, the short answer to your question is, I don't think that there would be liability for the city releasing something that is legally a public record. The liability would come if the city failed to release a public record that it was required to release under Chapter 119 Florida statutes. I'm happy to talk to you after.
We'll talk afterwards after that, definitely. Thank you.
Okay. Okay, so the next thing is ethics laws. So there are actually two codes of ethics that need to be followed in Palm Beach County. The first is found in Chapter 112 Florida statutes, and that applies obviously statewide. And the second is in the Palm Beach County's Code of Ethics, and that, of course, applies countywide. So generally speaking, the Palm Beach County's code is stricter. And what I can do is, after this meeting, maybe sometime tomorrow, with the assistance of staff, get you all a link to the Palm Beach County's Code of Ethics so that you can easily find it and that everything's all in one place. Okay, so most of the ethical concerns that I think would arise for purposes of an advisory board are going to center around voting conflicts. So generally speaking, the law says that you're not allowed to vote on something that would go to your special financial gain. So for example, if you owned a business that needed to have a special exception approved, you would not be able to vote on your own application. That's the simplest example I can give. Voting conflicts can get a lot more complex, and it's advised that if you think you may have a conflict, let us know ahead of time in advance of the meeting, because typically what I do is if we're in the middle of a meeting and a board member says, I think I have a conflict, I'm asking the chair if we can take a break so that I can talk to you about the conflict offline, because the last thing I want to do is embarrass any board member by asking personal questions back and forth in a public setting. So if you think there's even a question about it, let us know ahead of time. We can talk about it. You can also, like I said at the beginning, contact the Florida Commission on Ethics. They have a hotline, and they have attorneys available. They are very good at answering questions. At the end of the day, if you are hit with an ethics violation and you're required to pay money, again, this is something that affects you personally, and not the city. So now, if you do know that you have a conflict, first of all, this slide lists all the different, there are specific conflicts don't just apply to you. They apply to other members of your family, close members. And Chapter 112 is very specific about what who those people are: you, your spouse, household member, close family relative, employers, clients or customers, debtors, creditors, charities that you're involved with. So it's all looked at case by case basis. But again, this is one where I don't feel comfortable generalizing, and I think it's important that if you think there is an issue, you should come to us and we should talk about it. Before I get to this slide, this is going back to the Sunshine Law. If you do have a conflict, what you will have to do is you will have to announce the nature of your conflict at the meeting, and you will have to fill out a special form. Have any of you ever filled out that form before? Yes, okay, at least one board member. And once you announce your conflict, the best practice is that you no longer participate in the discussions. Any question about that? Because that's a hot topic too.
Yeah, because when you said no discussion, that kind of clicked because we have had discussions, even though we have a conflict, that we still can discuss what's going on, but we can't vote.
Right.
Yes. So what the letter of the law says is under Chapter 112, that once you announce your conflict, you can talk about it. You can legally participate in the discussion. But again, circling back to the issue, the appearance of impropriety, if you really wanted to just keep it as clean as possible, the best practice is not to participate. But if you wanted to actually walk right up to the letter of the law, you're not going to violate the law as long as you announce that conflict. And you can't participate in the discussion either as an advisory board member until you announce that conflict. So you can't hold it till the very end and participate in discussion and say, oh, by the way, here's my conflict form.
Sneaky.
That doesn't work. That's going to violate Chapter 112. That's one place where there's a different rule for elected officials. They get to do that, but advisory board members do not. I don't know why the legislature, sometimes they do things. I don't know.
Shocking.
So, okay. So again, individualized questions there. As a matter of fact, when I talked about the family members, even under Chapter 112, there are different provisions even that cite different family members. So again, come to us if you have a concern about you, close family member, even someone that lives in your household, client, customer, etc. Okay. The Sunshine Law, going back to kind of where we started, is found in Chapter 286. And that addresses the appearance or possible conflicts, right? Basically, what this provision says is you can't say, I don't want to vote on an issue because it's a hot topic and people are going to get mad at me and I'm uncomfortable, so I'm going to abstain. You just can't do that under Chapter 286. However, what the Sunshine Law says is you can abstain if you think if there is the appearance of a possible conflict. So if you think something is a little iffy, or if you have concerns, you can abstain under Chapter 286 and still be within the confines of the law there. There's another provision that allows abstention in a quasi-judicial proceeding if, for whatever reason, you would not be able to be fair. And I'll give you an example of that. Let's say that, for the record, this board does not do quasi-judicial hearings, but I'm going to talk about it soon, and I'll tell you why. But as an example, if you were, right? Let's say you got a personal phone call and had to step out of the meeting, and you missed half of the applicant's presentation, and you come back in and you have no idea what's going on with the discussion. That's an example of a situation where it may not be fair to the applicant for you to participate in the vote if you haven't received all the evidence, because a quasi-judicial hearing is more like a case that a judge decides on. So you wouldn't want a judge deciding on something for you when they haven't seen all the evidence. So that's an example. We talked about the form that you have to fill out and announcing your conflicts. And we're at the end of this presentation. Any questions?
Quick question.
Yes,
If you have
sir.
a board member abstain from a vote on a project, they don't explain why they're abstaining. They just say abstain.
They should announce the nature of their conflict and provide the form to be filled out. The form actually has to state the nature of the conflict as well, and that becomes a public record and is made available to the public. So Chapter 112 requires you to do that.
Mr. Sermon, I think we need to make that clear on the next email. When we send this email out on this, if you abstain from a vote, you got to go on the record, explain why. Am I correct, Ms.?
I would be happy if me or Christy, one of us, whoever's here that day, will be happy to remind you. If I hear a board member say they're
Well, we
abstaining.
did. We had a board member abstain
Okay.
from a meeting,
Last
and the
meeting.
attorney didn't come up and say anything.
Okay, well,
I let it be all.
And if I may, that abstain vote, we're not aware of if it was because of a conflict or they just did not want to cast a vote for some other reason. So
Okay.
I would add that to the conversation as well.
So that's a good point, and I would be happy to send a follow-up email because that's not on the slide. But yes, you should announce the nature of your conflict and fill out the form and move on. That's the way I would recommend that it be handled.
Okay.
So I won't speak to what happened before, and
I have a question as far as when we have companies come in and they have their own meetings and we attend those meetings sometime, would that be considered a conflict? Because it's just like sometimes we're invited to those meetings also, and I think it's a good thing. So that way we're hearing what the public feels about it also. But would that be a conflict as far as when it becomes up to us and to a vote?
so I think you might have a crystal ball over there, board member, because I have a slide for that.
Okay.
That's called an ex parte communication. And I will
I'll wait until you get to
I
it.
will get to that in just a second.
Perfect.
So you have, like I said, you have before you the packet for the first presentation. So we're halfway through. How am I doing on time, Mr. Sermons? Good? Okay. I'm going to fly through this as much as I can. So this is going to cover quasi-judicial hearings, and then some of the things that you see as planning board members, comp plans, rezoning, site plan review, special exceptions, exactions, and abandonment of public rights of way.
We don't have that presentation here.
You
so
do not have that
just wanna make
packet
sure.
yet, and that'll be provided
Via email.
with the email. Yes,
Thank
sir.
you.
Okay, so quasi-judicial hearings. Like I said before, this is not a technical quasi-judicial board in the sense that you all do not do evidentiary hearings. Those are done at the elected official level. However, there are some things in relation to how quasi-judicial boards conduct business that I think would be helpful to guide you in your conduct. And one of those things would be in the ex parte communication realm. So examples of things that are not quasi-judicial. The courts have spent a lot of time putting things that cities do into two buckets. One is legislative and one is quasi-judicial. Legislative things are policy related. They are making laws and policies for the city. Quasi-judicial things are deciding, they're actually applying those laws and policies to applications and facts that come before you. So as an example, if you are approving a site plan, you're going to be looking at what the code says, and you're going to be looking at the plan that's before you, and you're going to be comparing the two. You're applying the code. So that's why that would be quasi-judicial. Other examples are up there on the slide: variances, special exceptions, conditional uses, site-specific rezoning plats, and in some cases, the appeals from a lower board would go to the elected official level. Things that are not quasi-judicial are things that are more legislative in nature, and they are comp plan amendments, large-scale rezonings, text amendments, and other administrative actions. The reason why it matters, like I said, is because the courts will review a decision of a city that is legislative in nature with a lot less scrutiny. When you make a decision that's quasi-judicial, you're expected to be impartial. The board members are like judges at that point, and you're making a decision based on the evidence that you have received. So, ex parte communications. If we were in the world of courts and litigation, that's an absolute no-no. The judges do not have ex parte communications with witnesses, attorneys, anything like that. In this context, it's a little bit, you have more leeway. So if you were on a board that does quasi-judicial rulings and you had those ex parte meetings with developers, et cetera, you would have to announce that when it comes time for the hearing. You would be polled or should be polled as to what ex parte communications you had. Did you have such communications? Who did you have them with? And what was the nature of the communication? And once you disclose that, you protect the city from any attack that whatever was said was improper. Again, because you're not a quasi-judicial board, I don't believe that you all disclose those when you vote. Is that accurate in terms of how you guys have done things thus far?
Sorry, one more time.
Do you poll the board members as far as ex parte communications for planning and zoning?
I don't believe so.
Okay.
What we usually do is if we attend one of these community events involving a prospective development in their neighborhood, we might attend. And then I know some of us have disclosed that we've attended this community meeting by the developers and the community present. But we don't go into details. We just let it out there that, hey, we did attend that community meeting.
I think that's a great practice. Like I said, it would be required if you were not a purely advisory board. But I think it's a great practice to do. And also, I would mention any site visits that you did, any emails that you received, any phone calls, any voicemails. Okay, so moving on to some of the things that you actually see. Again, I'm not going to read all of these slides. I'll just hit the highlights. Comp plan amendments. So your code section is quoted above and consistent with Chapter 163 Florida statutes. The comp plan sets forth the city's plan for orderly and balanced growth. The planning board is designated as a local planning agency, and as such, you will review any updates and amendments to the comprehensive plan. In association with the comp plan is something you're going to see probably more often. This is probably more where the rubber meets the road for a planning and zoning board might be changes to the future land use map. So the future land use map says what kind of zoning districts can be allowed in various areas of the city. So you may have an applicant that wishes to rezone their property, but right now the future land use map doesn't provide the zoning that they want. So they're going to have to come in and request a future land use map amendment, and then they can come in and request their rezoning. Now, let me go back 1 second, sorry. Some of the things that you're not considering when you're looking at a future land use map amendment are site plans, permitting, all that stuff. You're not at that level yet. You're like 30,000 feet up in the air. The site plan is like, way down the road. So really the question that you're asking yourself for a future land use map amendment is this going to be consistent with the comprehensive plan? And those are questions that staff should be able to answer. Sorry, Mr. Sermons. Okay. Rezoning. Okay, chapter 31 is your zoning chapter. This is the bread and butter of planning, right? So it sets forth all of the zoning districts within the city. And it says what's allowed within each zoning district, and it sets the standards like setbacks, et cetera. Now, when reviewing an application for rezoning, again, you're now one level below what I said about future land use map being way up here. You're like kind of here now. You're still at a higher level. And what you're asking is, again, is this zoning consistent with the comp plan? Usually at this stage, you're not going to be considering site plans or very specific things unless you are approving something like a plan development that comes with a site plan attached to it. At that point, then you would be asking about the site plan. And yes, where are the dumpsters going? Where's the traffic going to go? What about landscaping, et cetera? So something else that you do, as you know, is text amendments to Chapter 31. Generally speaking, those are drafted by staff and presented to you for your comments and recommendations. Okay, site plan review. Section 3157 has a multitude of things for you to consider. They're on the slide here. Again, is it in conformity with comp plan? That's kind of like the Constitution, right? For this, you can't go against the comp plan. It's going to come up at every level. You have to make sure it's not going to be detrimental to neighboring land use. You have to make sure that it provides for efficient pedestrian and vehicle traffic. And you have to decide whether the proposed project will be a viable addition to the community. But like I said, your site plan is, again, those are the things, that's the time when you're going to ask where the dumpster is going to go and how's the traffic flow going to work.
That last comment is a big one for me.
Okay.
Love it. I'm glad it's there because I'm going to remember that when we have our next planning meeting.
Okay. I mean, I can tell you now it's a hard standard to apply. And we'll leave it at that.
Okay.
If I may on that one, how much latitude, being that that's the language that we have for site plans, how much latitude do we have to say, no, we don't believe it's a viable addition, even if, the use technically is allowed, but in consideration of that site plan being a viable use, what kind of latitude do our boards have in saying yes or no to that?
So at that point, your latitude comes from your evidence, and it's gonna be based on the information. In this case, the information that's received informally at the commission level, where it's quasi-judicial, it's going to be from the sworn testimony and the evidence in the record. So photographs, that kind of thing. You're going to have to be able to articulate why it doesn't fit in. So it's harder to articulate when you're talking about a broad general standard versus is the building over 65 feet or is it under 65 feet? But it's going to be based on the type of information received from the applicant.
Mhm.
I
And
don't believe we can use the viability clause for the sober homes.
So-
Hey, ma'am, thank you very much for that legal one at the very
listen,
end. Can we highlight that when you send it to us?
well, my goal is not to be controversial today.
I am using
and
that one. Where is the highlight?
We also, I will remind you that we also have to be careful because those fall under ADA and things like that. So you have to keep all of that in mind. But those are things that between legal staff and city staff, we can try to answer your questions and address your concerns. But that is what's in the code. So special exceptions. Special exceptions, the number of things that you have to consider are numerous and cover 2 slides. And I would assume the reason for that is this is not just a site plan that normally, or something of that nature that normally is going to get approved more likely than not. This is something special that someone is asking for. And therefore, the code is set up such that you're to consider all of these factors such as ingress and egress, vehicle pedestrian safety, off-street parking and loading, and effects on adjacent property where applicable. Again, dumpsters, refuse and service areas, utilities, and utility hookups, screening, buffering, landscaping, any signs. I mean, is the applicant coming in with blinking signs, things like that? Required yards and open spaces, and other factors that might be specific to the special exception that is before you. Generally speaking, those things should be reflected in the site plan. Okay, so unlawful exactions. So an exaction is a request for an applicant to pay an ad hoc fee to make some sort of land donation or some other financial contribution. So what is in exchange for an official action? So that's like saying, donate this piece of property in exchange for the city granting your application for X. An ad hoc fee is not your standard application fee. It's a special, it's a specific amount of money tied to that specific applicant's specific request. The U.S. Supreme Court has considered this issue on at least 3 occasions, and they basically come up with this rule that says that if you're going to, an exaction that has no nexus to the actual project or that is disproportionate to the actual project is going to be illegal. So, for example, if you have an applicant that's looking to develop a 1-acre parcel and you say, right, okay, in exchange for that, we want you to donate 20 parcels to the city. That's going to be disproportionate, grossly disproportionate, and it's probably going to lack nexus to the impact that they're going to have. So something more reasonable might be you're developing this piece of property. You need to give the city an easement so that we can have access, for whatever reason. That's probably not going to violate the rules set up by the Supreme Court. And then just in general, even if you're not demanding, even if you're not requesting a donation, a fee, or any sort of financial contribution as part of approving an application, in general, conditions of approval should not be arbitrary. They should be proportional and relevant to the applicant's request, and they should be consistent with whatever's in the code. So again, you're going to have to look at the specific application that's before you. What is the applicant asking for? What does the code say about it? Right-of-way abandonments, I'm told you did maybe 2 or 3 of these in the last year. So there are multiple considerations. And again, this is something where, if you have one that's pending before you, I think it would be helpful to be reminded when necessary of the different things for consideration. But this is what the code says you should be considering, whether it resolves existing incompatibilities, whether it's an alley or designated as a secondary street. Generally speaking, primary streets are not eligible for this unless there's special circumstances. Is the applicant providing a new route? Will the proposed relocation maintain or increase public access to the waterfront? Will the relocation create a block that's larger than 2,000 feet? That's not allowed. And will the proposed relocation support the marine industry, whereby vessel size it necessitates the increased dimensions of the parcel? So again, that's going to be a very specific circumstance that would come to you in a very specific context. So that is the end of the general things that in my limited experience with this particular board, I think might come before you. If you have any questions, let me know.
Mr. Sermons, I believe on the right of way, your team comes up with the reasons why the approval merits the abandonment.
Yes, we structure our staff reports currently such that if there's a criteria such as site plan approval, special exception, or even abandonments, that in the staff report, the criteria is listed and then there's a staff response as to how the applicant is or is not satisfying that standard. So we include that information in your reports.
You also, when they approach the lectern, they also, on the night of their presentation, they go over the same facts. So we should be covered on that.
They may not necessarily itemize each criteria and how they're meeting it, but that's, again, why we provide those staff reports to show that we've looked into that before bringing it to you. But in their presentations, they don't necessarily
Not each one, but they highlight
they highlight what they want to bring to your attention with the projects. But just know that staff, we are here as your resource, as your technical expert, as an advisory board, and when it gets to city council, because they're going to have their experts that are going to bring the things that they believe are most relevant. But you are relying on us to identify those criteria and tell how they've met or have not met based on our professional opinions here.
So yes, I didn't mean to discount your wonderful resources.
Oh.
The staff reports are definitely going to be your go-to. So
Mr. Brown? Mr. Gallen?
I have one. The only really concern that I have is that we're making decisions while we're in the process of making changes to the comp plan. And by us not knowing fully what the comp plan is going to be, but we're still making these decisions and letting people come in and build and everything else. That's my main concern, right now.
I understand that. I'm going to I'm going to let Mr. Sermons comment on that if he wishes to do so.
I would say, I think technically the existing comp plan is still the law of the land. And if they are proposing something that is consistent with that, then they are, what they are developing is consistent with the plan. And I think legally that's the outlook that we would have to take. If we're mindful of certain things that we want to change in the comp plan, I think we can bring that up, and I think we have. And so with certain projects and push for certain things as there's been zoning in progress, so to speak. But I believe they still have the rights to ask for anything that's consistent with the current plan, or some of the projects involves amendments to the future land use map of the existing comp plan. And at the current moment, that is the governing document for development in the city.
We can't make a decision on a future comp plan which hasn't been approved by our legislative branch and approved by the state as well after they approve it. So
Right.
basically, we have to go by what the law of the land is.
Well said. That's why I kicked it to you.
I have one more question, but mine actually go back. Are you done with the presentation, or
I
is this open
am.
for questions?
This
Okay,
is question time.
okay, got it. I want to go back to the part about I'm a stickler when it comes to certain things,
Okay.
and when we talk about violations, when you talk about the Florida Sunshine violations or what we have, I know we talk about what the penalties would be that we would have in the city, and looking at the list here where you said the action is void, criminal penalties, removal from office, non-criminal infractions, depending on what was done and what was said or what happened, depends on which one of these, or is there a certain step progress to what they're going to do?
Okay. I can walk you through that.
Okay.
Okay. So there are certain things that this is not necessarily a progressive list. Okay. Let's take the criminal and civil penalties. Okay. So if you violate the Sunshine Law and someone, if it's established that you violated the Sunshine Law, right? But you didn't intend to do it, it was inadvertent. You saw a board member in Publix and you were chatting and the conversation veered and someone in the next aisle overheard you and reported you, and you're found to have inadvertently violated the law, right? At that point, you could be fined up to $500. If you violate the law on purpose, that's when you get into criminal penalties, and that actually happened in the city of Sebastian. Some members of their governing body decided that they were going to have a closed door meeting, that they were going to lock the public out, and they made decisions in violation of the Sunshine Law, and I believe 2 of them were given jail sentences as a result. So that is an egregious example and an example of intentional violation of the law. So as to things that apply to board members, it all comes down to, did you do it on purpose or was it clearly intentional? But again, I don't like to walk right up to the line of the law. I like to stay like 1,000 feet away from that line, which is why if you ask me, I'm always going to tell you, be careful about your interactions.
Clarification, when you said about the 2 people talking inside the grocery store and someone on the other aisle heard them, I don't think that's unintentional. Because someone else caught them talking about something that they shouldn't have, that's intentional, because they just happen to get caught in that situation. So at that point, and I guess I'm getting to the point to where I'm looking at this and I'm thinking that given what we have here, and I think for us to move forward in the city, that this needs to be progressive, like you stated. And I think it should start off with removal from office, because first thing you do is you sign paperwork to be on the boards, and you sign paperwork to be on city council and whatever board you're on. So we know the rules and regulations about being there, but we don't kind of go back and forth with that depending on who it is or what the situation is. Once that law is broken, it is broken, and that's it. And at that point, number 1 should be removal for office. Then number 2 should be criminal penalties from that standpoint, or whatever that is. But removal for office should be a standard.
Well,
because there's no intentional or unintentional in that. It's either you did or you didn't. And I'm not trying to be funny or anything
No,
like
I
that, but
understand.
we do understand what the law is, and we're all pretty much educated to be, so we know what it is. And when we say something, we know what we're doing. So to go back and say, well, I didn't mean to say that. No, it's too late. It's already been broken. The law has already been broken. So I don't get to rob a bank and then come back and say, well, I didn't mean to take that much money or whatever. No, it doesn't work that way.
I was smiling not because I think you're being funny, but because I'm looking. So government law is a second career for me. I was a prosecutor for a long time.
Mm-hmm.
And a lot of times it comes down to what can be proven based on the facts. It's very hard to prove somebody's state of mind. So when you lock the door and you lock the public out, that's a heck of a lot easier to prove as a misdemeanor than it is to prove what someone's state of mind was. So that's really where that comes down to.
Yeah.
As far as, how the city treats these violations in terms of its boards, and, that's something that for the elected officials to decide. There are provisions for, under Chapter 112 Florida statutes for certain, upon a conviction of a misdemeanor for people to be removed from office, there are provisions under that chapter if that were to occur. As far as the other things that affect the city specifically, like the legislation being void, the civil actions that can be filed against the city, the attorney's fees that the city may have to pay, all of those apply across the board.
Right. Okay. I just and like you said, I got called into jury duty, and you're absolutely right. The information that that was given, that we had to prove beyond a reasonable doubt and prove what a person's mind state was. So you're absolutely correct on that. It's just that given what we have in our city, I just think that being on something that's important to what our city's future is, it shouldn't be a fine line for that. I know the government operates in a different way, but I don't think it should be a fine line with it. Either it is or it isn't. And if so, and once proven that has happened, then step 1 should be removal from office. I'm done.
Noted, and well said. Thank you, sir.
Thank you. Wonderful presentation.
Okay. All right. Thank you for your attention. And Mr. Chair, remind me of the things that I need to follow up on. I did not bring my pen up here, so I'm going to send you
Email the two
the two presentations,
presentations.
the
You
link,
were going to add also a link to the county.
yes, to the county ethics.
And
I'll
that,
also send you the Florida Commission on Ethics.
okay.
And there, I feel like there was something else that I was missing.
I would remind the board members that if they're going to abstain, they're going to have to explain, especially if they don't fill out the 8B.
That was it. That was it.
That's
Yes.
important.
Yes, they must fill out for me. They must
But
fill
if
out that form.
if they don't fill it out and they want to abstain because of a personal reason, like they don't agree with the massive development, that's not a,
Even if
you
they
can't.
don't fill it out in the meeting, they have to come back and fill it out at a later
Exactly.
time.
that should be, yes, Ms. Shepherd.
May I ask her to clarify abstaining and saying no? I just thought that I never seen that done before. I would have just said no. So give me the definition of abstaining and the no. What, is it the same? Is it different or?
I think that's a very good question. So, abstaining means I'm not going to vote at all. It means I'm recusing myself from this issue. I have a conflict or the appearance of a conflict, or I cannot be fair in a quasi-judicial setting, and therefore I'm not going to vote at all. But what you can't do is say, I'm not going to vote because this is controversial and my neighbor's going to be mad at me. So I'm going to just say I'm not voting so that I can stay out of it. You have to vote. And at that point, it's either one way or another, yes or no.
So I often abstain if I'm not present during a meeting, I will not vote on the meeting minutes because I wasn't there. So I'll abstain and I'll explain that I was not present for those meeting minutes, what was said during, so I obviously can't vote on it.
Chair,
Yes.
one more question, and maybe I missed it or whatever. From what Mr. Shepherd's saying and Mr. Fernandez about abstaining or saying no, let's say the person fills out the information for what the reason was, and let's just say that explanation isn't suffice for the board or isn't suffice for the council, whatever like that. At that point, then what do we do? Are they forced to vote, or what other methods are taken?
Well, when it comes to issues that fall under Chapter 112 in ethics, at the end of the day, everybody is personally responsible for
Absolutely.
themselves.
Right.
So that's why I said it's very fact specific. Ask questions ahead of time if you have concerns, talk to the Commission on Ethics. Because if you at least get some direction, then you'll feel more confident that you're doing the right thing. If someone doesn't do the right thing, at the end of the day, that's on them. That's their personal responsibility. And the proper forum for that to be enforced is before the Florida Commission on Ethics.
Any other questions? Once again, thank you very much. Great presentation
Thank you.
tonight.
Board.
No problem. It is now, Mr. Sermons, do we have anything else before we adjourn?
Nothing else from staff.
Anything else from the board? It is now 7:40. Do I have a motion to adjourn?
Second. Oh, did he make a motion?
No, do we have a motion to adjourn?
So moving.
First, Ms. Shepherd, second, Mr. Gallen. We are adjourned.
Thank you.
You can tell I want to go.